Hello, everyone. My name is Andrew Taningo Jr., a second-year business diploma student, and today I'll be discussing the defenses to defamation in the context of business law. Specifically, we'll focus on fair comment. But before I start with the topic, I'm going to share with you my PowerPoint slides so you would be able to understand more the details of the topic. Let's start with the basic definition of defamation, coming from our book, Managing the Law, The Legal Aspects of Doing Business, chapters 5, page 114. Defamation occurs when the defendant makes a false statement that could lead a reasonable person to have a lower opinion of the plaintiff. This concept is crucial in protecting individuals and businesses from harm to their reputation. A statement is only considered defamatory if a reasonable person would think it referred to the plaintiff. This is a broad requirement. The defendant doesn't need to have intended to defame the plaintiff. It's enough if a reasonable person would believe the defendant was talking about the plaintiff, even if it was a mistake. Defamation only applies to living persons, which includes people and corporations. Companies can sue for defamation, but dead people are not protected. So you can say bad things about people after they die. Liability can occur even if the defendant didn't name or clearly identify the plaintiff. The key question is whether a reasonable person would think of the plaintiff when hearing the defendant's comment. Defamation can happen through any form of communication, including spoken words, which is slander, written documents, which is libel, gestures, photographs, and even puppet shows. Almost any uncomplimentary statement can be defamatory if it could harm someone's reputation. For example, suggesting someone is incompetent, dishonest, or involved in a criminal activity can be a defamatory. Let's also discuss the distinction between slander and libel. Slander is a defamatory statement that is spoken, while libel is a defamatory statement that is written. Regardless of the form, defamation can occur through any sort of communication, including gestures, photographs, and even puppet show. One notable case in Alberta that involves the defense of fair comment in defamation is the case of Dr. Huff and Dr. Zuck, which I found in the CanLII website, which is the Canadian Legal Information Institute. In this case, it provides an excellent example of how the defense of fair comment operates in defamation law. And it highlights the importance of balancing freedom of expression with the protection of reputations. This case also demonstrates how malice can undermine a defense, making it highly relevant for understanding the challenges that both individuals and businesses face in navigating defamation disputes. The case arose from statements made by Dr. Zuck about Dr. Huff, who was the chair of the Alberta Dental Association of Colleges Advertising Committee. Dr. Zuck accused Dr. Huff of bias and inappropriate conduct within the ADAC, publishing statements that were damaging to Dr. Huff's reputation. Dr. Huff sued for defamation, claiming these statements were false and harmed his professional standing. Dr. Zuck, on the other hand, argued that his statements were protected by the defense of fair comment because they were opinions on a matter of public interest, specifically the governance and operations of a professional regulatory body. The court carefully examined the requirements for fair comment as laid out in defamation law. According to the textbook definition, the defense of fair comment requires that the statement be on a matter of public interest. Number two, be an honestly held opinion. Number three, be based on true facts or privileged material. And number four, not be motivated by malice. In Huff versus Zuck case, the judge acknowledged that the topic of regulatory body governance was indeed a matter of public interest. However, the court found that Dr. Zuck's statements did not meet the criteria for fair comment because they were not based on true facts and were motivated by malice. This application demonstrates how the textbook definition was upheld while emphasizing the importance of intent and factual accuracy. The judge ruled in favor of Dr. Huff, finding that Dr. Zuck had defamed him. The court concluded that Dr. Zuck's statements were false, not supported by true facts, and made with malicious intent. Consequently, the defense of fair comment failed. The judgment includes damages to compensate Dr. Huff for the harm caused to his reputation, aligning with the textbook principle that remedies in defamation cases often aim to restore the plaintiff's reputation and provide financial compensation for the harm suffered. This case is particularly instructive for future business leaders. It underscores the importance of ensuring that public statements, especially criticisms or opinions, are factually accurate, supported by evidence, and free from malice. For business leaders, navigating public relations and communications responsibly is essential for avoiding legal disputes and protecting professional relationships. Additionally, this case demonstrates how defamation law balances the right for free expression with the need to safeguard reputations, an ongoing challenge in the business world where public perception can directly impact success. In conclusion, the Dr. Huff versus Zuck case is a powerful example of how defamation law operates in Alberta, particularly in the context of the defense of fair comment. It highlights key lessons about the importance of truth, intent, and accountability and communication, principles that are invaluable for anyone navigating the complexities of business and leadership. As future business leaders, understanding cases like this equips us to communicate responsibly, protect reputations, and foster trust in our professional relationships. Thank you for listening for my presentation and hope you understand the topic. Thank you.